a certain point from the investigative report. Attorney General Edward Buckingham and Director of Procurement and Supply, Herman Sablan, reviewed the determination to award the contract as a sole source award to IPS. Buckingham acknowledged that ethics concern existed and that ADDA had a conflict of interest. He thought, however, that the need for the contract outweighed ethics concerns. Sablan said he felt that the sole source award was justified because the justification indicated that the Attorney General reviewed the document. He acknowledged that he simply relied on the Attorney General's opinion rather than his own review of the document. So, Mr. Sablan, I take it that you were more or less counting on the Attorney General's judgment. Am I correct?
That is correct, because I do not have any legal counsel with my office.
Okay. Thank you, Mr. Sablan. Thank you.
Thank you, Rep. Any members? I have a few. First to Mr. Sablan. We have the packets of information which includes the contract. Are there any other memorandums or anything else, correspondence that should be in here that are not in here?
No, sir. No, sir.
Okay.
Everything's in here.
I take reference the memo from yourself, Director, to the Governor, dated October 12th, where you basically return the contract without approval, and you reference the reason for not approving it. So initially you did not approve the contract, and you reference section 70-30.3-245, which states that this section provides that an award of a contract shall be made only to responsible contractors. One of the requisites for the director to determine that a contractor is a responsible contractor, the contractor must have adequate financial resources to perform the contract or ability to obtain them. Would either one of you like to explain what this section, elaborate on this section, and why the contractor was rejected or not approved?
This was approved on the basis that the governor responded back. So I said, however, in this instance, advance payment may be made pursuant to Northern Marianas Island section 7030.3-401B4, whereby the official with expenditure authority submits written determination that paying the contractor in advance will result in a specific advantage to the government. So,
Counsel, you may want to help out here, but
I honestly,
I'm trying to.
I don't know the circumstances
Well,
behind this letter.
Okay. I'm trying to understand this because the director's memo to the governor basically denies or rejects does not approve of the contract for a very specific reason, and that is that the contractor is not responsible, a responsible contractor, that they have to provide or demonstrate, I guess, adequate financial resources to perform the contract or the ability to obtain them. to obtain the resources, financial resources, to perform the contract. So that was the basis for non-approval. First, we have to look at this first. The director states, but then the governor responds back, and I do see a memo on the next page, same date, from the governor to Mr. Sablan, October 12th, responding to that memo, stating Mr. Michael Ada's expertise as the CNMI's lead for the ARRA grant, I guess, is of great value to the CNMI. His proposed contract for integrated IPS will also be a direct advantage to the Commonwealth. As Expenditure Authority, I hereby determine that his request for advance payment is reasonable and hereby authorized. So, first, if we kind of look at this in order, Director says, Governor, I'm sorry, I'm returning this disapproved for this reason. He's non-responsive. He doesn't have the financial resources or the ability to obtain the financial resources to perform the contract. Then you have a response from the governor saying, as Expenditure Authority, I determine that his request for advance payment is reasonable and hereby justified, which doesn't really respond to the denial or the citation or the reason for denial. It just says that I determine that you can give an advance payment. And then the last paragraph of the first memo to the governor says, however, in this instance, advance payment may be made pursuant to Section 70303, 401B4, whereby the official with the Expenditure Authority submits written determination that paying the contractor in advance will result in a specific advantage to the government. I don't know if I am off track here, but the first part of it talks about an apple and the second part talks about an orange, and somewhere in between the first part and the second part is a response. It just doesn't match. He's responding to a letter before that, or to a memo before the memo even came. In the same memo that the director disapproves the contract. So somebody please make sense of this to me.
I believe the governor made the response on the same date that I sent out this letter to him.
Mr. Director, with all due respect, you raise, pretty much you disapprove the contract for a specific reason. The governor writes back for something else. He doesn't respond to the reason that you raised. Nothing here in his letter memo says that he is now a responsible contractor and we should approve the contract. And by the way, you can pay him in advance. There's nothing in here that justifies maybe overruling your denial of the contract or your non-approval of the contract. Nothing. You kind of respond to him, and it looks very awkward, by the way, that in the same letter that you're raising the matter to him, you're answering him about something else. I mean, it's... Counsel, do you want to find out or try to answer this?
I really don't. I don't quite know what was behind the
Okay, let me
when we started these letters. I honestly don't know.
I apologize if I may have had too many things at one time. First question then, just a yes or no. Was the contract initially not approved by Procurement and Supply, yes or no?
No.
It was, let me restate that. Did you approve of the contract in the October 12th memo?
Yes.
Sir, let me read again. Governor, with all due respect, I am returning the subject contract without approval at this time. And I would like to remind you, you are under oath. Did you approve of the contract on your memo dated October 12th?
No, I don't remember, sir.
Sir, you have a memo in front of you with your signature. Counsel, please.
I wasn't involved with this. I think
You have the memo in front of you.
yes. I don't honestly. I don't know what this was all about, though.
Mr. Chairman?
Okay,
I think honestly,
we'll
maybe-
come back to this. I recognize Vice Speaker.
Mr. Chairman, what does that first paragraph mean for you? I mean, what were you telling the governor with that first paragraph? I mean, referencing section 70-30.3-245. Can you just tell us what that section means?
I think this is a responsibility of a contractor.
Meaning that he has to have money, he has to have staff, and other things, equipment and whatever, to be able to perform the contract, right? Or is that my reading? I mean, am I correct in that interpretation?
Yes, the contractor should have
And then
have financial capability to finance the project, or the ability to obtain, borrow money from the bank or wherever.
Right. So the second paragraph, the last paragraph, what does that last paragraph means?
The last paragraph is in response to the governor's letter to me.
No, can I just, maybe I'm not making myself correct, but that last paragraph, could it just simply means that he could advance? I mean, advance payment can be made to him?
No, the governor justified the advance payment.
That October 12th letter was written, and even before the governor responded, you were already telling the governor that this is the requirement, that you must, that the contractor has to show that he's able to perform the contract. He has the money, he has the staff, he has the equipment, he has everything. And then in the last paragraph following, you're pointing out that the contractor may advance. Is that what I'm reading? Or am I reading it correctly? That the official with expenditure authority would need to submit something where, that will be the, who is the expenditure authority that we're referencing here? Submits written determination that paying the contractor in advance will result in a specific advantage to the government. And then when the governor responded, isn't he responding to that request by saying, as expenditure authority, I hereby determine that his request for advance payment is reasonable and hereby authorized. I'm just trying to clarify.
Thank you, Vice Speaker. That's exactly what I was trying to understand and clarify. You're also trying to understand the same thing.
And to me, there's nothing wrong. I mean, I don't see anything. I'm satisfied with what you told the governor and what then the governor responded, telling you that he hereby determined that his request for advance is reasonable and hereby authorized.
Chairman?
Vice, are you done?
Should that request be made?
Okay, thank you. Representative De La Cruz.
Yes, just to chime in on the issue here at hand. It's quite clear that Mr. Sablan's memo, dated October 12th, was a disapproval letter to the governor, as stated in the first paragraph. However, we are all pretty much trying to grasp the last sentence, wherein Mr. Sablan had disapproved, but yet it appears that he is approving the advance payment to be made to the contractor. So I'm just as a bit confused with everyone else here. Mr. Sablan, this memo of October 12th, where you stated that the subject contract is without approval, may we ask who was the legal counsel that wrote this memo? And may I ask also, what is, after your signature, there is an HS VML? Is it a VML?
Yes.
Yes. Who is this person, or is
The HS is the originator of the letter, and the VML is the typist, is the clerk.
Oh, okay. So they basically have this copy of this memo.
Yes, sir.
Again, going back, who was your legal counsel at the time that prepared this memo, or did you prepare this by yourself?
I prepared this myself. I don't have any legal counsel.
You didn't have any legal counsel?
No, sir.
Okay. Thank you, Mr. Sablan.
Thank you, Rep. And I apologize. I think I got kind of wrapped up and was confused and maybe a little bit frustrated. And I apologize, Mr. Sablan, if I may have insulted you. I'm sorry.
That's all right, sir.
Mr. Sablan, just a few more things. Under one of the provisions when there is a conflict of interest, restrictions on employment of present and former employees, is that a written statement of disqualification should be written by a government employee to the Director of Procurement and Supply. Was there a letter or written statement from Mr. Adda to your office asking, or basically getting a determination whether he should be disqualified?
No, sir.
Are you or the council familiar with this requirement?
I'm familiar with it. I haven't dealt with Section 245 very much as legal counsel, so I really can't say much about it. If I may.
Please.
I would usually think that Section 245 would be in regards to a contractor, saying, doing construction work or something along those lines, something where something expensive, something where you need to know that the company is of the size and of the reputation to be able to do this work without getting halfway through a contract and then leaving the road in disarray and then them going out of business or something. I'm not really. I'm not really sure what kind of resources Mr. ARRA needed to do his work under the services contract. So I would think that he would only need so many people working with him and not expensive heavy equipment or anything like that. So I'm not sure. I would think that normally 245 wouldn't necessarily apply to work like that, but I could be wrong. I don't know. I don't know the exact what exactly he did for that would have required, that would have implicated 245. But that's without me knowing more about the situation.
Chair. Let me just address that point. Actually, it's on Procurement and Supply Regulations 70-30.3-740, and it's on restrictions on employment of present and former employees. And let me just read it. B of that section says, restrictions on former employees in matters connected with their former duties. Permanent disqualification of former employee personally involved in a particular matter. It shall be a breach of ethical standards for any former employee knowingly to act as a principal or as an agent for anyone other than government in connection with any, and in this case it would be a contract, number 2, contract. And so the report, the Inspector General reports, further states, while still the Secretary of Commerce, Mr. Adda participated directly in the IPS ARRA management contract, in which he and his company had a financial interest. We found no evidence that Adda ever filed a written statement of disqualification with the Director of Procurement and Supply. And that is the reason I posed that question. Was there ever, in your knowledge, evidence that a written statement of disqualification was sent to your office?
No.
Thank you. Representative De La Cruz.
I'll yield for now, Mr.
Council, I have to go back to an outstanding issue that hasn't been clarified. Please help me clarify this issue. And it goes back to the memo of October 12th, where the director returned the contract without approval because the contractor was non-responsive. How was that ever addressed? I mean, I understand there's the last paragraph talks about paying the contractor in advance, but those are two different things. I just want to focus on the first one. Was it ever addressed, the non-responsive determination by Procurement and Supply? And how could we have gone to the signing or approval of a contract without any supporting documentation that addresses the non-responsive issue?
I don't know. I wasn't involved in this, so I don't know what exactly happened in regards to 245. My guess, and this is a complete guess, this is a guess. My guess is that there was a thought that maybe 245 actually doesn't apply. As I said before, I think 245 would normally apply in larger capital-intensive, labor-intensive projects. It wouldn't be my first thought to think of 245 being an issue for a contract like this, but I don't really know what the whole scale of the contract would be. So perhaps it was just dropped, but I don't know. You can speak to Mr. Sablan about that.
Thank you, Councilman. That's the reason I asked earlier if this contract was complete, if the correspondence, the memos were in here, because you would normally find a paper trail. If something is important, or in this case, it's actually a disapproval of a contract, and then you went on to find a copy of the contract fully executed, one would wonder, did they override the director's authority? You know, if there's some evidence in there that points to, well, there's a memo of, October 13 saying legal review found that 245 was not relevant in this case, and then something, but in the absence of it, it raises suspicion. And I think you, as an attorney, would understand that or appreciate that. And in any legal contract, all that should be disclosed and transparent. I will yield for now. Members, I have no further questions. If the members wish, we can. Representative Tabatet.
Just a few clarification on the processes for contracts to Mr. Sablan or Mr. Carney for that matter. So we have a contract in front of us and it's all signed. And so before all the signatures are complete or put together, then there are some conditions that needs to be met. And some of those conditions will be, what would be the first condition that is required of a contract to be executed? We need the justification. We also have the so-called sole source justification from the expenditure authority. Is that correct?
Yes, that is correct.
Can you also go down maybe generally how that works so that I can understand the process? In awarding contracts, so in this case, the sole source contract, we have a project, we have a pending, we have money for this project, and then how does one go about to secure this contract or sole source contract?
As long as the expenditure authority justifies the contract, I think that is all that is needed.
Okay, so and then the justification comes from the expenditure authority, and then they process the contract to first the finance or the procurement and supply?
The expenditure authority submits the justification with the contract, and after I sign off on it, it goes up to finance for fund certification.
Fund certification.
Then to the Attorney General for his review, and then to the Governor.
Final.
And then goes back to me for final, for certification of contract completion.
So then we have a binding contract after all the signatures are taken care of.
That is correct.
As you have mentioned. And the last one was dated by the Governor, and then the procurement and supply October 12th. Is that correct?
That's correct.
And then the governor signed it on October 13, whatever the date is, but all signatures, all required signatures are in place October 13.
That is correct.
I mean, it's kind of in line with what the chairman is alluding to, because in October 12, all things were considered, including the response from the governor to you, as responding to your letter dated October 12, where the chairman indicated that you had reservation or concern, and then that you required that the authority, if the expenditure authority submits written determination that paying the contractor in advance will result in a specific advantage to the government. You send that to the governor responded that, and I think the vice speaker mentioned that, read that as the expenditure authority. This is the governor's memo to you. I hereby determine that his request for advance payment is reasonable and hereby authorized. That was the only determination. And I think that's what the chairman was trying to get more clarification on. Is that our understanding?
Yes.
So, and then the request for advance payment, who's making this, his request for advance payment? Is this the contractor or is this the expenditure authority?
Normally the contractor will request for advance payment, but in this case I think it's the governor knows that the contractor don't have the financial capability to proceed with the contract.
Yes. And so, and that was the first advance payment dated, I think in the report it says on that day that the contract was executed.
Yes.
Everything is in place.
Right. Yes.
Do you require, before all the signatures, do you require something from the contractor to submit for consideration for an advance payment?
Yes, normally the contractor will ask for advance payment. I don't know if the contractor asks for advance payment, ask the governor for advance payment, but normally the contractor will ask for advance payment.
So any contractor can request for an advance payment even if the contract is not completely signed by all the required individual signatures?
No, the advance payment has to be after the contract is complete.
All requirement on the contract needs to be in place before an advance payment is issued.
Yes.
Mr. Carney.
At the schedule on payment terms, which is under attachment 3, I think, A3, I think this says here the first payment is after completion of all contract signatures. So perhaps that is what is meant by the advance payment.
That's the 20% we're talking about.
Yeah.
And I was just asking Mr. Sablan that all things needs to be in place before any advance payment is issued by finance, correct?
That is correct.
So even including business license, is that correct?
Including
business license of a contractor.
Yes, the business license is required after the contract is executed.
Okay, thank you, Mr. Chairman. Thank you. Mr. Director and Council. Again, in the October 12th, one last point about this October 12th memo, where the director basically disapproves the contract for a reason that it is not responsive. In accordance with section 70-30.3-245, I went on to that section. I asked for a copy of that section, and it lists what a responsible contractor is. To be determined responsible, a prospective contractor must, 1, have adequate financial resources to perform the contract or the ability to obtain them. I believe that's the reference that Mr. Sablan used in disapproving the contract. There are others, but since it doesn't apply here, I won't go down the line. That's the relevant section of the regs. But there's also another section, 7D, which talks about non-responsibility determinations. This is a non-responsibility determination made by Procurement and Supply. And it states, when a bid or proposal on which a contract award would otherwise be granted or be made is rejected because the prospective contractor is found to be non-responsible, a written determination shall be signed by the Procurement and Supply Director stating the basis for the determination, and this shall be placed in the contract file. That is 70. That is this memo, correct, Council? Yes or no?
You're referring to the October 12th memo
Yes. Yes.
From the...
It's a non-responsibility determination.
Chair? Well, I actually...
You don't have the regs. I can show it
Yeah.
to you.
I've not been involved with a non-responsibility determination, so I don't know how they would normally look like,
Okay.
or what particular language they would use.
Okay.
But I can see...
Chair?
Maybe when you finish. Are you finished?
No,
Yeah.
I think this is related to what we're...
Go ahead. Go ahead, Representative Torres.
We asked our legal counsel to print out 70303-401B4 so we can compare the difference here.
Rep, I think that's a different part of the regulations, and that has to do with advance payments. So the first part is saying that the contract is non-responsive, and then on the last paragraph is the regulation you're referring to, saying that an advance payment may be made. So this memo basically states two things. One, that the contract is rejected, and then two, that an advance payment may be made. I yield. Any further questions? Representative Torres.
Chair, this is not a question but making a statement. The director's letter to the governor on October 12th telling the governor that he is returning before his approval on the contract, citing the section 70303-245. But on the last paragraph it says, however, governor, you can make an advance payment provided that the Mr. Adda would make or submit a advance request. Then the governor can make an advance because the governor is the expending authority. That's what happened when the governor wrote back to him on October 12th also. You know, that he is going to do it. And then on October 13th, Mr. Sablan, concurring, telling the governor that the contract is complete. So I don't know what we're discussing here. That it's a simple letter from the director to the governor. I understand it already since last hour. I don't know why we're spending.
Well, here's the problem. Here's the problem. There is a problem. And I think Representative Tebeteb just clarified that problem with procurement and supply. That the only way for an advance payment to be approved is if the contract has been executed and signed by everybody. I think Representative Tebeteb clarified that point, that the only way for an advance payment to go out is if the contract is valid. But that doesn't, this memo doesn't point in that direction, Rep. The contract is returning it without approval. So how can you issue or even request an advance payment without approval first?
Mr. Chairman.
Please clarify.
Now I know about this. I told the governor that according to the justification he made here, the advance payment is justified pursuant to 401Bs of the regulations.
I see the 401B. I have the regulation in front of me. Council, do you want to weigh in on this?
I'm just speaking to Mr. Sablan about we're both trying to figure out what I understand that there's sort of two different things going on in here, and so I think we're just both trying to jog Mr. Sablan's memory about this and what exactly may have been going on.
Because we cannot advance all the money.
Yeah. Well, you didn't just 20%, but he said, standards for advance payment determination are the recipient is otherwise qualified as a responsible contractor in all areas other than financial capability, and paying the contractor in advance orders on specific advantage to the government. So you think? My thinking is that perhaps the problem is he didn't have enough cash on hand to start, but then maybe 20% payment would have enough cash so he can start.
No, we can go up to 50%.
Not 50%.
Not exceed.
Yeah. But it was 20%.
But
yeah.
I think that should not exceed 50%.
Yeah.
Yes.
Yeah. Do you think that's it? Do you think that that's what I was saying before might be the case that currently didn't have enough? Money for 20% was given to him, but that's
You ready, Council?
Yeah, I think we were speaking about it, and I think what may have been the issue is that at the time where this on October 12th, I think maybe the thinking was that he Mike ARRA didn't have the financial resources to perform the contract at that time. But maybe if he was given the 20% advance payment, which is actually fairly common. A relatively large or advance payment or payment at the very beginning of the contract is fairly common, so that it allows the contractor to start performing without having, because many of the costs are incurred at the beginning of the performance of a contract. So the idea is that the 20% is given at the very beginning, which would then allow ARRA to perform the contract and make him, at that point, capable of performing the contract. 401B, it says here, standards for advance payment determination are B3, the recipient is otherwise qualified as a responsible contractor in all areas other than financial capability. So if Mr. ARRA was capable of performing because he had the required knowledge of how to do the job, all he's missing is the capital to actually start hiring employees and getting office space and etc. That would be a reason why an advance payment would be fine. And also paying the contractor in advance will result in specific advantages to the government. That would be an example of, for the essentially the same reason why Michael ARRA would be picked to have done this job, which was that he could have started doing it immediately. He had he knew everything about the job. He knew how to do it, and could start immediately without endangering the funds moving forward because of tardiness in getting a new person up and ready to do it. I think that's probably what this is about. It could have been stated more clearly, so we apologize for that, but I think that's the idea.
When was the contract signed? Or fully executed? Or legally valid? When was the date that it was consummated? Please.
I believe October 13th, 2010. That's when the last signatures are on.
Thank you. Now, Representative Tepetep asked the question that advance payments can be made, but it is made normally after a contract has been executed. Is that correct?
That's
true. Yes or no? Yes or no?
Yes.
Okay, thank you. You just clarified that the contract was executed on October 13. Is that correct?
That is correct, sir.
Thank you. And you know what is not inconsistent? I'm familiar with contracts. Yes, advance payments can be made initially. That is a very true statement. But only after a contract has been executed. Now we are looking at requests for payment, advance payment, prior to a contract being executed. Normally, when the request for payment occur after a contract is executed. Yes or no?
That is correct, Mr. Chairman. As a matter of fact, any contractor should not incur any expenses prior to the completion of the contract.
Thank you, Mr. Director. Thank you so much. I have no further questions. Thank you. Any member before we dismiss Mr. Sablan? If not,
just clarification.
go ahead, Vice.
The question that you posed was that the payments, any payments shall not be disbursed, or is it request for payments to be made? Can requests for payments be made in advance, but the payments shall not be disbursed? Is that what we're saying?
In a contract, advance payment means that the the contractor will receive the money before he starts the project, you know, to get him on track.
For clarification, go ahead.
Yeah, I don't believe there's anything against the regulations for asking for an advance payment. Like I said before, I think it's under certain circumstances it would be standard for fairly soon after the contract completion for an advance payment to be made. And I honestly don't know if there was an advance payment made before contract completion, but I believe there wasn't. So I'm not sure the letter of October 12th, because it's made before October 13th, I'm not sure that in and of itself makes it, just its state makes it illegal. But certainly a payment before October 13th would be, I think, illegal.
You know, it wouldn't probably not look very unusual had the same memo not disapproved the contract. Maybe if there was reason to believe that the contract, in the memo, this contract is approved. You know, in that memo, this contract is approved, and Expenditure Authority, you may submit a request for advance payment in accordance with the relevant regulations. What's unusual about this is the memo does not, you know, approve the contract, and an advance request for advance payment is made. Mr. Sablan.
Mr. Chairman, I have nothing to do with the payment. It all goes up to finance.
Thank you, Mr. Director. Thank you very much. I yield, Vice Speaker.
Yes, and I think that's the last one. The contract was signed October 12th.
I think we just had that clarified that it was signed on October 13th.
Well, the procurement and supply director, because of the question that he was asking, the section of the contract where he had to sign off, it was very clear. He signed off on the 12th, saying and certifying that to the best of his knowledge and belief, the contract is in compliance with the CNMI procurement regulation, which leads us to understand and affirm that the contract has been, he is satisfied with what his request has been satisfied, and therefore he signed the contract.
Vice, could you take me to the relevant document?
Chair, I'm looking at the contract itself.
Where in the contract? What page?
Under Director, Procurement and Supply.
Give me a page, please.
Page, it would have to be page 12 of 13.
Okay, well that is the
Page,
director. Right.
That's with that signature, he's signifying that to the best of his knowledge and information that he has received, his belief that is that the contract is in compliance with the CNMI procurement regulation, and he signed off on the 12th.
Correct, but I believe the question is, when was the contract executed? It's not the procurement and supplies signature that executes a contract, Vice. I think the legal counsel affirmed that. The contract is executed when the governor signs it.
And the governor signs it on the 13th, if that's your question.
That's when the contract is valid. And that's why the legal counsel and Mr. Sablan said the contract is executed on the 13th. Correct. Are you any further? If not, we need to move on to the next witness. Mr. Sablan, thank you so much.
You're welcome, sir.
Thank you for being here, and thank you for your patience and your honesty. I really appreciate that.
Thank you.
Have a nice day. You too, Mr. Katni.
Yes.
Thank you.